Good afternoon and welcome to Identifying and Quantifying Government Contract Claims. My name is Peter Ford. I'm a partner with PilieroMazza. PilieroMazza is a law firm dedicated to servicing the needs of government contractors and commercial businesses. We have four main practice groups: government contracts, which is what we're going to be talking about today with respect to claims and appeals and REAs. Labor and employment, business and transactions, and litigation. We have offices in DC. We're headquartered in DC, and we have offices in Boulder, Colorado, which is where I work out from, and Annapolis, Maryland. And I have the pleasure having with me today Larissa Simkovich with Baker Tilly. And Larissa, I'll let you speak to Baker Tilly.
Thanks, Peter. Hello, I'm Larissa Simkovich with Baker Tilly. Peter mentioned where his offices are. A bunch of us have recently gone remote at Baker Tilly. So I recently moved to Denver from DC just a year ago, but we have a lot of folks kind of all around the country now post-pandemic. That's definitely something that's come out of COVID for us. I'm also in the government contracts group here and work with all phases of the procurement cycle, basically, with our government contractors, helping them from proposal preparation to incurred cost proposals, DCA audits, and of course, claims and investigations as well. Another area where we overlap is with the SBA and 8A program. I'm primarily working with tribal organizations with that program as well. Baker Tilly in general does a lot more than just the contracting system compliance with government contractors. We've grown quite a bit, and we have a host of other offerings, from cybersecurity, as you can see here, to digital modernization, which has definitely grown over the past 5 years. So we have a lot to offer our government contractors, and we really like being able to be a one-stop shop for our clients. Peter, I'll pass it back to you to give the overview.
All right, thanks, Larissa. So today we're going to be talking about REAs and claims, somewhat at a high level, but kind of give you some tips and tricks for whether you should file an REA, a claim, things to consider before you file. We're also going to be talking about how do you quantify a claim, or how do you quantify an REA? In other words, how do you determine your costs or your numbers of days of delay, or both? Then we're also going to be touching on an overview of the claims and appeals process. If you submit a claim and it's denied, what do you do after that? You do have the ability to enter questions to the chat box. Larissa and I will save time, or try to save time at the end to answer them, but you can insert them as the presentation is going along, and if there's a particular question that is of particular relevance, we may just stop and address it mid-presentation. So with that, we'll get started. So the biggest question we get when clients approach us with a potential issue with a contract where they need either additional time, additional money, or both is, what do I do? Do I file an REA? Do I file a claim? They've heard these terms, but they don't know exactly what they mean. So the biggest difference between an REA and a claim is that a claim is a formal claim with the contracting officer, and an REA, which is a request for equitable adjustment. There's no official definition of an REA, but generally for both an REA and a claim, you're seeking a request for either time, money, or both. For an REA, it's typically filed when the contract is ongoing and during contract performance. An REA is a relief in equity. It's a relief in fairness. You're essentially asking the government to work with you when there has been some change or issue that you have encountered, such that you should be entitled to additional time or money, or both. An REA falls short of a claim in both procedural requirements and formality. There's no specific format that is required, and it's relatively informal. Whereas with a claim, you're submitting a written demand seeking the payment of money in a sum certain. You have to submit the specific amount that you're requesting and provide documentation to support such. A claim is filed under what's called the Contracts Disputes Act, which I'll refer to as CDA throughout the rest of the presentation. And it's a formal dispute. And if it's not resolved at the claim level, it may lead to litigation through the appeals process. And if it's not resolved through the appeals process, you may go to actual litigation in the federal circuit. You can go to the next slide. An REA should generally be submitted anytime during contract performance or closeout. But importantly, it can't be submitted after the contract has been closed out. If you are performing and there's an issue that arises generally, you just submit the REA roughly within 30 days of that change that gave rise to the REA. This 30-day deadline, it's not a hard and fast rule. You're not necessarily going to be barred if you don't meet it, unless the government can somehow show that it was prejudiced by the failure to submit the REA within that 30-day time. And that generally means that the government says, you know, had you submitted this REA earlier, we would have done something differently, or we would have saved money, or something along those lines. But generally, the rule of thumb is to submit it within 30 days. Again, it's not an absolute rule, but it's a good rule to adhere to. As I mentioned earlier, there is no particular format required for an REA. It does usually take the form of a letter to the CO explaining the basis for the REA and support, meaning exhibits. The best thing to consider is that you prepare a REA as if you were submitting a claim with that level of detail, because a lot of times REAs can turn into claims. Note that with an REA, there is not necessarily a dispute, but it should be detailed enough to provide the agency with sufficient information regarding the basis and the amount that you are seeking, time, money, or both. You should include the details, the basis of the REA, how you calculated your costs, and obviously what relief you're requesting. Generally, it should just be as detailed as you can possibly make it. And at least outside of the DoD context, there is no recertification requirement. And I'll touch on that certification requirement for DoD REAs on a later slide. One of the biggest pieces to consider of an REA is the preparatory cost, including your attorney's fees, admin costs, your internal costs, meaning the cost of the time that you spend preparing this REA. Those are all recoverable as part of the REA. But again, the REA really isn't and shouldn't be presented as a dispute, at least at this point. It's really a negotiation with the government. You're working with them, they're working with you, and you can include your attorney's fees and costs, as well as your internal cost. But when it does become a dispute, you are no longer able to include those costs. So if you are still working with the agency throughout contract performance and they say, for example, yes, we recognize that there is a change, just submit an REA for that, you would just submit the REA, and in that instance, you could recover your costs. However, if the agency has come to you and says, we're not paying for this for you, you know that now you're in a dispute such that you may want to consider filing a claim as opposed to an REA. Moving to claim basics, as indicated, there are differences between an REA and a claim. The right for a contractor to file a claim is recognized under the CDA. And in accordance with the CDA, a contractor may within 6 years, and that's the magic number 6, from the date of accrual, assert any claim as against the government to the CO for consideration. The FAR incorporates the requirements of the CDA into contracts. A claim does have a definition. It's defined under the CDA as a written demand or assertion by one of the contracting parties seeking as a matter of right the payment of money. A sum certain, the adjustment of interpretation of contract terms, or other relief arising under or relating to the contract. And the same goes for claims as REAs, in that there is no particular format required when filing a claim with the CO. It just needs to constitute a clear and unequivocal written statement that gives the CO adequate notice of the basis for your claim and the relief sought. We often recommend to clients that a claim include all relevant documents and correspondence to support the claim, mostly because the more detail you have in an REA and in a claim, is likely more to get to a better result. If you end up appealing the claim, you are bound to that information that is actually cited in the claim itself, which again is another reason why you want it all in there. Meaning, if you don't include certain information in your claim and then you go to appeal it, you can't then essentially amend the claim to supplement it with additional information, which is why you want to get all the information, documents, and support submitted as part of the claim itself. So what happens after you submit the claim? After the contractor submits the claim, the CO must either resolve the claim within 60 days from receipt, and that's for claims under $100,000, or the CO has to notify the contractor of the date by which the CO will issue the decision. The contracting officer is required to issue a written final decision in response to a submitted claim. And it's important to note and to reiterate that unlike REAs, the fees for preparing a claim are not recoverable. So now we'll move to certifications. So certification with REAs, as I mentioned previously, REAs generally don't need to be certified. The exception is for DoD contracts when the value of the REA exceeds the simplified acquisition threshold, which is $250,000 currently. When that occurs, you must include a certification stating that the request is made in good faith, and two, that the supporting data that is being provided is accurate and complete to the best of your knowledge. Additionally, an REA is typically submitted prior to there being a dispute, which I think I referenced in a prior slide. And when there is negotiation, and if the REA exceeds $100,000, which is the threshold requirement under the CDA for a claim, you can actually convert the claim or convert the REA into a claim by complying with the claim certification letter that we'll discuss in the next slide. So when you're submitting a claim, you're seeking damages. The contractor is required to request a sum certain in the claim. When a claim is made against the government exceeding $100,000, a contractor must certify that the claim is made in good faith and that it is accurate to the best of the contractor's knowledge and belief. The specific language for certification for a claim is set out in the FAR, and the certification under the FAR clause must specifically state several things. One, that the request is being made in good faith, that supporting data is accurate and complete to the best of the submitter's knowledge. Three, that the amount requested accurately reflects the contract adjustment for which the submitter believes the government is liable. And finally, four, that the submitter is duly authorized to certify the claim on behalf of the contractor. And as far as authorization is concerned, it's normally the president or the CEO of the company that's executing the certification that gets incorporated into the claim. And with that, I'll turn it over to Larissa.
Thanks, Peter. So now we're going to move on a little bit. Now that you set the foundation really well with REAs versus claims, we're going to move on to a little bit more of the details of the two, starting with when would you file the REA or a claim? Peter mentioned before the difference between the two. Timing is a big component of it. Just to reiterate, right? REAs are going to be submitted either during the contract, as soon as you know that there's going to be a change that needs to be requested for equitable adjustment, you're going to have that request. It's imperative to have a good relationship with the government there. So be in contact with your contracting officer. Hopefully it's amicable. We know it's not always, of course, but to the extent that you're able to maintain that relationship, it's going to hopefully help you be able to stay in that REA category before switching to a claim or a dispute. So if you have those conversations, if the government seems like they're saying that they're willing to have an amicable resolution, typically then you're able to submit that REA. Again, keep it amicable. Hopefully you can do that and be able to keep it the REA. Keep in mind too, one of the key things that Peter said earlier was related to what you can recover. And we'll hit this a few times throughout the presentation, but you can recover those preparation fees for REAs. So definitely good to be able to keep it in that bucket. The claim, sorry, I'm still on that one. The claim, if there is animosity, or for some reason, if the contracting officer just simply disagrees with you, that they don't believe you're entitled to the equitable adjustment. Try to avoid that term dispute. Don't assume that it's a dispute, of course, but at some point, whenever the government indicates that they disagree with you, that's really when you're going to switch into the claim there. And there's some examples, even if you have a good relationship with your contracting officer, it doesn't necessarily mean they're going to accept the REA. Some of the things that we're seeing right now are still related to COVID, right? Everybody's looking at the costs that they're incurring from COVID, from maybe some of their people being sick or some tests that they need to provide. How are they going to be recovering those costs? I've seen several contractors who have tried to submit REAs actually related to COVID-related costs, and it's a complete hit or miss depending on agency and depending on contracting officer. So we'll see there. I think also areas to keep in mind going forward are going to be inflation and your supply chain hits that are happening right now. Potential additional squeezes of time for supply chain, and what does that look like? How does that impact your contract? And are you eligible for an REA there? So just some things to keep in mind. But there are areas that you can pursue that are outlined in regulation or otherwise. And typically you're entitled to your actual costs or time, like Peter mentioned before. Sometimes you can also recover some of the reasonable profit depending on the type of change or claim that you're going to be submitting. We have a bunch of examples here of different arguments and issues that you can pursue that are outlined. We could talk for hours on each of these. We've selected a few of them to go through in somewhat of detail, or at least cover here in our hour that we have with you. But of course, each of these can kind of be their own presentation in and of themselves. So what we're going to do is give you an overview of the common examples and really the key components that make up each of the dollars for these. And the first one we're going to go over is going to be the delay claims. So for delay claims, for whatever reason, if your contract is delayed and you go to ask for a claim here, there's a lot that you can try to recover. It's important to identify all of the costs that are associated with it because they may not be very clear at first. Direct costs, of course, are something that are tangible to everybody, but don't forget the indirect cost increases that are there too. So whenever there's that extended performance period, what happened there? Did your direct labor for some reason have to switch to indirect labor? Make sure that you're able to track your people's time for any kind of delays that are there. Is there potential stagnant time that exists? Is it simply that they are taking longer than expected because of something that the government did, right? Make sure that you're tracking all of this specifically. Good time notes are important. And then also maybe you're going to set up a different WBSE, maybe even to track some of these as well. Unabsorbed home office overhead that occurred during that extended period of performance. Material costs. Did you miss out on purchasing efficiencies potentially because of that extended performance period? Maybe you have an average inventory system where you are able to take advantage of purchase orders with other contracts, and then all of a sudden you can't anymore and your prices increase. I mean, that's up to the government then, right? So consider how you're accounting for your costs and take a look at what is the cause of these shifts in material costs. Lost productivity caused by the delay. Let's say you have to stop for any sort of reason, or you have to slow down, or maybe you're only using one of your 10 engineers for the time being. The ramp up time for those 9 engineers, that's understandable, right? We're all human. We're not robots. We're not able to just hit the go button right away and pick up where we left off. It's going to take us a minute to remember our efficiencies and get back to that. So that lost productivity and ramp up time can be included in those claims as well. Just make sure you're documenting everything very, very clearly. Can't stress that enough. Make sure everything is understood, why you have these extra costs or what the costs are related to, which costs are related to what you were reasonably expecting versus what's above and beyond as well. Continuing with the delay damages, make sure you're interviewing all of the potentially impacted departments. Treat this as an internal investigation. The indirect rate application, is it simply a straightforward indirect rate application, or are there specifically identifiable costs? Like we mentioned on the previous slide, for example, you might have people who shifted to indirect. Does that make sense? We really probably shouldn't treat those people as indirect that get allocated to your other contracts. So let's keep them as a reason that you had this delay and document that. I interview all of your different departments there. Do you have increased training costs? Were people trying to make use of their time while they had maybe downtime? Document all of your incurred costs too, of course, capturing that timing and the reason why anything was impacted. Make sure you identify any costs that may have already been reimbursed by the government. You just want to make clear, trying to be friendly with the government, right? That these are costs that are already reimbursed. They happen to be related. Acknowledge that so that you're not trying to double dip on the government, of course. And then estimate your future costs too. If you have delay damages, maybe you're in the middle of it and you can see other costs that are going to be impacted in the future. Figure out what those are, identify those separately as well. This whole effort should really resemble what you would go through in a proposal process whenever you're responding to an RFP. You may ramp up the people who you're going to have included in that, and include your consultants. Make sure that you're taking this very seriously so that you can get the correct estimate there. Peter mentioned before, keep in mind what you're going to have to certify and what is going behind those certifications. Are you making your best effort to really capture those costs and making sure that they are reasonable and they're justified? Differing site conditions. So this must be something that's actually a physical condition of the job site. You have to keep in mind the timing here. So was it something that existed at the time the contract was executed? It has to be. It can't necessarily be something that happened after the fact, right? That's a different type of change there. And the condition must not have been discoverable during the site inspection, right? So just like you're responsible for submitting to the government everything that you reasonably know at the time of your proposal, they're also supposed to tell you everything too. So if you're doing a site inspection, you have the ability to see the differing conditions, then it doesn't really count. That's up to you and who you hire to make sure that's your expert who is doing the walkthrough. There are two types here. There's either the type where the site differs from the conditions that are indicated in the information about the job provided to bidders. So let's say, for example, you don't actually get to walk the site, but they give you a detailed description of what the site is going to be. Maybe the site's in a different country. Maybe the site, for some reason, you just don't have access to until you win the contract, which happens, of course. So then you have to rely on something the government says. And if that's the case and you get there and it's completely different, document it, right? I'm going to say that until I'm blue in the face. Document anything that you see that's different. Document your assumptions based on what they wrote. But that's the first type there. The second one is a little different, but obviously related. The unknown and unusual condition that differs materially from what is ordinarily encountered on the particular type of work in that particular locality. So this is based on your experience. If you have experience in that particular area and you have certain assessments from previous conditions and this one differs significantly, that's an opportunity for you to be able to show that, right? Because you'll have it documented, you have it from your past experience, and you'll be able to bring that to the government. Now, terminations. So what we've been going through so far is we've been really talking about changes that happen during your contract, right? So it's something that's tangible, that has changed, and you're trying to identify the impact of those changes. Terminations are a little different, right? So you have the two types here that we're outlining of default and convenience. Default, that's your contracting officer final decision. You'd have to appeal that in order to get it overturned. Default, you're not able to get anything from default, right? That they're saying you, the contractor, did something wrong. We don't want to see any of you in that situation, of course. But then your defenses will be submitted as a claim. Termination for convenience, the government can do at any time, right? And hopefully there's no bad faith there. But with the convenience, this is where it changes a bit. It's not about the change that happens during the contract, but it's about your entire contract and what you've incurred so far. So the calculation becomes extremely different than the other changes for REAs and claims that we've been talking about thus far. In order to track the costs for your terminations for convenience, make sure you stop work and track them immediately. Rely on your accounting system, track them separately. Similar to how you would have pre-contract costs and you'd identify those separately, identify anything that happens after that stop work order that you get from the termination separately as well. Hire people for this. Make sure that you have support and identifying what your costs are going to be. Government agrees to pay all of your reasonable allocable costs plus profit on these costs with limitations for lost contracts. We include that language specifically because the cost piece is important. If you have a fixed price contract and it's terminated for convenience, all of a sudden it turns into a cost type contract because you get to go through all of your incurred costs, and that's what is going to be the basis of your essentially claim to the government here. And there's a bunch of different areas to consider. So again, this is what makes it a lot different than the others that we've been going through before, but there's a lot of like your pre-termination expenses, for example, what's included there. So you want to make sure you included everything from that contract, from the pre-contract costs, your initial startup costs. A lot of times those are disproportionate, right? Those are typically at the beginning of the contract. Do you need any kind of facility improvement, NREs on your manufacturing equipment, anything like that? If there's any completed end items already, you're including that. Any of your unpaid expenses. So if you have any accruals that are on the books, something that you can prove, right? Something that's already accrued, those get included too. And any of the inventory that's already purchased. All of this is going into those pre-termination costs. So anything that's been purchased, it's been supplied to you already. If there's something that's been built, but has been acquired for performance, you already have an expense on your books for those costs. Basically, the risk of loss is typically on the contractor, so preserve that, protect it. Conduct a physical inventory to get your numbers here. Don't necessarily rely on your electronic records. They're great, they should be reliable, but take that extra step and do your physical inventory so you know what's really on there, just in case there. That's just your pre-termination costs. So those are all the things that we didn't really even talk about with delays, right, or any of the other claims or REAs. Your termination cost is really what you typically get into there, and this is where you're going to be hiring your people. So Peter said for REAs, you get to recover any of the costs that are essentially your settlement costs, your preparation costs there. Similarly, for terminations, you'll be able to recover your settlement costs as well. So any of your settlement expenses. Your other termination costs are going to include any of those costs that you can't discontinue immediately, just despite whatever's going on. So those are, you have to make your best effort. Of course, you have to be able to show that, make sure you're documenting it. Why are your termination costs not able to stop immediately? It just has to be reasonable, right? There's certain costs also that are going to continue after termination. Think about your continuing salaries or your severance. You may not be able to, you may be hiring people specifically for one contract, right? And if that's the case, then what are you supposed to do with them right after? You can't just fire them day one. Are you going to try to use them on another contract? What is your policy there if your contract is terminated? You can put that in the employment agreement and say, we will try to, shift you to another contract within X many days. those X many days would be a part of your cost of continuing after termination. So get all of that on there. Severance too, have a policy. Do you have to pay these people now that you have to fire them early? Get it all documented. Look at your union agreements as well. There's cost of completion for those things that we talked about in your pre-termination costs that you have maybe manufactured that are halfway there. Do you need to complete that, or are you going to have to dispose of them? Those are all considerations in your termination. And like I said, I'm sorry I'm rambling through these so quickly, but you could have an entire half a day on terminations or a whole day on terminations training. But it's important to get all of these costs together here, because that's going to be your full performance cost. And the last piece that's on this slide for terminations is this loss ratio. The full performance cost, as we just outlined above, that is taken in comparison to your contract price. And then that's attributed to the cost incurred thus far. And that's the amount that you're able to recover there. So it's called your loss ratio. Excuse me. So all of this sounds pretty complicated, right? We just spitting a lot at you. Use your experts, use your consultants. A lot of times you're going to you may have to go to the court, make sure that you're hiring your lawyers as appropriate and getting them involved at the right time. Even if it's giving them a heads up saying, hey, we're going to submit an REA. It might be something a little bit less then, but then once it switches to claim, obviously you have a lot more help that you can use from your lawyers. And if you need consultants to help out too, a lot of times our clients don't have the staff to simply pull these together. We have people who are busy on proposals, right? But not necessarily people who are ready and waiting to submit an REA or claim. So make sure that you have the people there for you. These amounts have to be calculated based on reliable principles and methods. Make sure they're based in regulation. Make sure they're certified, like Peter was saying before. And that's really why you want to make sure that you're including all of your experts that you need to. Keep in mind too, the last part, your attorney shouldn't be preparing the delayed damage calculation. They'll engage somebody else just to make sure that they are not a material witness in litigation, that they're staying independent of the delayed damage calculation there, right? That's just a little tidbit in best practice.
Yeah, and I'll just add to that. We do not help prepare delayed damages calculations. We rely on experts like Larissa. It's just something that's not in our wheelhouse, and it's generally not in any attorney's wheelhouse. Right. So yeah, it's just another point on using experts and consultants.
Yeah, absolutely. Circling back to REA versus claims considerations. Peter, I know you mentioned a few of these earlier, but they're important to mention again. So REAs, those preparation costs, generally allowable. As soon as you switch to a claim, they're no longer allowable. It says it so on the FAR, so be careful of that. Hopefully you're able to get something in REA. And then the other piece here is related to interest. So we haven't talked about this quite yet, but the interest can't accrue for an REA. It's something that's usually more forward-looking, or like Peter said, you have up to 30 days after the contract to go ahead and submit the REA. There really isn't time for interest to accrue if you think about it that way. So you don't really want to sit on it. That also goes towards just having a good relationship with your contracting officer as well. That's something that you want to be doing real time and submitting real time. The claim, the interest does accrue on claimed amount. I mean, think about claims, they're going to go through the legal system. That's going to take some time. You're absolutely able to get your interest on those claims. Reasonableness. So reasonableness is something that everybody in government contracting is used to, right? It's one of those words that's probably branded somewhere on your body. But when it comes to REAs and claims, don't forget about it. This one was really interesting. There was a case with KBR, and we're going to ignore the False Claims Act violation that came from that later. But before that, what happened is there was a subcontractor that submitted, I believe it was 2 REAs to KBR. because of delay. And they said the delay was related to the government. KBR accepted it. However, when they dug into the details, the board basically found that the basis of the estimate was inaccurate. This is related to something that was happening in the Middle East, and the subcontractor basically said that there was a certain number of trucks at the border. Well, the board found that there was significantly less trucks than what the subcontractor was suggesting, and unfortunately, KBR didn't see that. There was also unclear evidence that really the government caused the delays, so they overturned it because of that as well. And then finally, they also said that the costs were not supported as reasonable in KBR's calculations. And this is the key here. It's really because KBR didn't do their due diligence, of inquiring a little bit more of the subcontractor. So it ultimately ends up being the prime's responsibility to make sure that they're reimbursing their sub of what they should be, right? Well, the government found that KBR didn't really do that due diligence, so therefore the government didn't reimburse KBR. KBR had reimbursed the sub, I believe it was 48 million, and basically the government said, nope, we're not doing that. They estimated somehow the 3.783 is what the government ultimately did give to KBR, and that was related to, you know, a little portion of it that they deemed was reasonable, but that was a huge hit for KBR. So make sure that everything is supported. We cannot say that enough. Peter, I think I'll pass it over to you.
Thanks. So the next thing we're going to talk about is knowing the limits of government authority, and specifically who has the authority to bind the government. Why is this important? Why is it relevant to REAs and claims? Well, if there's a change that wasn't appropriately authorized, and you perform under the assumption that it was appropriately authorized, and you incur costs as a result of that change, then you may be barred from recovering those costs. So that's and again, this entire presentation really is talking about being able to recoup time, money, or both. So that's really where we're going to hit on this topic for the next few slides. So the short answer is, with respect to who has the authority to bind, it's the contracting officer. And oftentimes we'll get calls from clients saying, well, the contracting officer's representative or technical representative told us to do X. But if the CO has no idea that this happened or didn't authorize the action, generally those representatives do not have authority to bind the government or issue instructions. So this is a key point that everyone here needs to understand, making sure that whatever direction you are following comes from the contracting officer, or at a minimum, the contracting officer is copied on the communications and or followed up with after the fact. And if you actually look in your contract, you're going to see a clause explaining who has the authority to bind the government. And generally, it's only the CO. There may be the ability for the CO to delegate this authority to the representative or technical representative. But I guess the key takeaway here is look in your contract to see specifically who within the government agency has the ability to bind. And if it's not, for some reason, designated in your contract, you should get a separate written letter or email from the agency specifying who does have the authority to bind them. This is very critical as it comes later on. If the government counsel, when they get to either the claim or during the appeals process, they're going through their files internally to see who told you to do whatever it is you're saying you were told to do. And if it's not the contracting officer or someone with an ability to bind the government, often their defense is going to be, well, shouldn't have followed that direction. Obviously, as a small business contractor or any contractor, you want to please the customer, but you just need to make sure that whoever you are aiming to please has the authority to bind. So when is the government bound? So along those lines, the government should be bound when you're given direction by an official who acted within the scope of his or her actual authority. Again, it needs to be actual authority, not apparent authority. So So again, look to your contract to see who has the actual authority to do so. Sometimes there is an argument regarding implied actual authority, which could arise when maybe in one instance, for example, the government intended to grant authority in writing but failed to do so, or the contracting officer was copied on all of the communications such that he or she should have known the direction was given, or knew the facts at least going on such that he or she would not be able to come back later on and say, I had no idea that this was going on. But ideally, the communications will be directly with the contracting officer, but of course, we recognize that oftentimes the CEO is not the individual on the ground and is not the individual giving the work or direction, although they should be. Again, the important point is you should confirm with the CEO before you do anything, if at all possible, or at a minimum follow up after the fact, saying on such and such date, I was told this, I was told to do this, this is what we did, and as a result of that, this is what we incurred in terms of costs, just so that you have at a minimum a record of those internal communications if and when you need to file an REA or a claim, so that you can explain that the authorized official, most likely the CEO, was aware of what was going on and ratified whatever action that you took. So the government has a duty to cooperate. And frankly, this is often an argument that we make in a request for equitable adjustment or a certified claim to the CO. The implied covenant of good faith and fair dealing. It's actually a common law principle, which essentially says that every contract imposes upon each party a duty to cooperate in good faith and deal with each other fairly. This is also applicable to federal government contracts and commercial contracts. The Board of Contract Appeals, which we'll get into a bit later, and the Court of Federal Claims have long held that each contracting party has an affirmative legal obligation not to hinder performance or prevent the other party from attaining what they term the fruits of their bargain. In accordance with this, the government has a duty to cooperate with all aspects of a contract. When the government does something that on its face suggests underhanded activity, this is where an implied duty to cooperate argument would come in. So I guess a couple examples would be if for example, the government was refusing to open the gates and that prevented you from being able to perform on that particular day or days, that may be a breach of the duty. Or if they just for no reason failed to approve an individual security clearance, then that may be another reason to cite as a breach of duty. And you may have a claim to make to just showing that they're failing to cooperate. I will say that this is often heavily dependent on documentation of performance and interactions with the CEO or other members of the government. You want to ensure that you have a supporting record if you're making this argument. One thing to note is that bad faith right now, at least, is not an essential element of a breach of the implied duty of good faith and fair dealing. And if we were to argue bad faith, that it's extremely, the standard at least is extremely high, and it's very difficult to prove. So it's a good thing that it's not an element at least right now. So waivers and reservations of rights. So another thing we often try to remind our clients is making sure that when you're executing modifications, that you're not waiving or releasing any of your rights. Contractors often need to be extremely wary of any waiver language prior to executing any type of change or modification to their contract. When working with the government, we often find that the government will try to include any type of waiver language in a contract mod that would release them from any liability for any action or inaction prior to the execution of the modification or change. It's also important to note that waivers and releases of rights can be an absolute bar, and this is what I get into at the beginning, to recovery of costs under the contract. So oftentimes we'll have a client come to us and unfortunately they want to raise an argument of the excusable delay, and then we'll look at the modification that they executed 2 months prior, and they have already released their rights prior to that modification, meaning they're barred from recovery. That would limit any amount of excusable delay that they would try to make in an argument to extend the performance period. If the release language is unambiguous, a contractor is more likely stuck with the plain and ordinary meaning of that release. So our best advice is that if you think there's a possibility of a claim or an REA, that you make sure to reserve your rights to raise it later. Keep in mind that you have 6 years to file a certified claim, as we mentioned earlier. So you definitely want to make sure that you protect your rights to do so before executing any type of change or modification. So I guess just in terms of how does this work practically, well, a lot of times you'll be issued what's called a bilateral contract modification. And it's bilateral, meaning that both parties have to agree to it, meaning you have to sign it and the government has to sign it. So if you're reviewing that contract modification and it contains strong release language, do not be afraid to push back, meaning propose to the government edits to the REA, edits to the mod, and specifically edits that allow you to reserve your rights. It really is a back and forth process. If, on the other hand, they issue what's called a unilateral contract modification, then you don't necessarily need to worry about having waived any rights because simply by virtue of issuing a unilateral modification, your rights are preserved. So now we're going to do a brief overview of the claims appeal process. So we're talking about a situation where you have filed a claim, not an REA, and the claim has been denied in whole or in part by the CO. So we're just going to do kind of a quick overview. So as we mentioned before, after the contractor submits a claim, the CO must either resolve the claim within 60 days from receipt or indicate that they need additional time by notifying you and give you a date by which they think they're going to be able to issue that decision. And once that written decision comes down, and assuming it's bad, the contractor has options. So the first option will be to take it to a board of contract appeals, and that's going to be either the Armed Services or Civilian Board of Contract Appeals. And I'll just use the term board for the rest of the discussion on this. The other option would be to take the appeal of the claim to what's called the Court of Federal Claims. But just keep in mind that whatever you choose in terms of forum, then you're then bound by that forum decision. And that's what's called the election doctrine. And what that means is you cannot appeal to the Armed Service Board or any board, get a negative decision, and then try to appeal to the Court of Federal Claims. It's one or the other. But one thing that can be done is both board and COFC decisions can then be further appealed to the U.S. Court of Appeals for the Federal Circuit. So what to expect? And we'll start with what to expect with respect to appealing to boards. If a contractor is unsatisfied with the CO's decision, you can appeal the decision to the appropriate board, and you have to do so within 90 days of receipt of the decision. As compared to the Court of Federal Claims, an appeal to a board is often a little less formal and less costly for our clients. For instance, there's no fee to take an appeal to the Board of Contract Appeals. All that is required is a written notice of appeal, which can then be sent via email to the appropriate board's recorder or clerk. And then once that notice of appeal is received, the board will then docket the case and send a docketing notice to the parties. Then the contractor has to file a complaint, and that complaint is due within 30 days of the notice of docketing. And then under the rules, the government has 30 days to answer after being served with the complaint. And then simultaneously with that, the government will serve up what's called a Rule 4 file. The Rule 4 file consists of all the documents that are in the government's possession that are relevant to the appeal at issue. One good thing about boards is that they have what's called a small claims procedure, and this is available for claims that are of $50,000 or less for small businesses. The appellant, the small business, if they want to elect that procedure, they have to do it within 30 days at the receipt of the agency's answer. And then the presiding judge has to resolve that appeal within 120 calendar days. Another option is what's referred to as accelerated procedure, and this is for claims of $100,000 or less. And here again, the appellant has to make this election for procedure no later than 30 days after receipt of the agency's answer. And for this process, the board has to resolve the appeal within 180 calendar days. Okay, so what to expect if you're going to the Court of Federal Claims with an appeal. As far as the other form option, COFC, there's less of a rush to file the appeal. If you're taking it to the Court of Federal Claims, instead of this 90-day window, you have a full year. And once that is filed, the government will then have 60 days to answer after being served with a complaint. Obviously, if you don't know, the COFC is more of a formal forum, and can also be more costly for our clients due to the formalities. Another difference between appealing to the boards and the court is that you're no longer dealing directly with agency counsel. Once an appeal is filed with the Court of Federal Claims, a DOJ attorney will be appointed, and they represent the agency, and they'll take over the case as lead counsel. Oftentimes, this 60-day window for the government to answer is extended, and more often than not, it's because the DOJ attorney needs more time to get up to speed on the facts of the case. Under the rules, though, the parties can also request an expedited trial schedule through what's called a joint preliminary status report. And again, this is available under the rules of the Court of Federal Claims. This expedited procedure is often appropriate when discovery can be completed within a 90-day period. A case can be tried within 3 days. There are no dispositive motions, such as motions to dismiss or motions for summary judgment. And here the parties are seeking what's called a bench trial, meaning only the judge will be presiding over the dispute. Finally, I wanted to get into what's called alternative dispute resolution, ADR. It's available at both the court and at the boards, as well as some agencies. It's essentially a tool to use if you aren't really looking to go to trial or go all the way through the appeal process to a decision. And instead, you can use mediation or other methods such as arbitration, binding or non-binding. You can use it before or after the contracting officer's final decision. And if you submit a claim and you haven't got a decision, but the agency is really willing, you may be able to go through the ADA process at that point. Board or a board judge will often encourage the use of ADR if it sees that the matter can be resolved without having to go to a final decision. And it's even possible that you could do ADR prior to filing an appeal. But I think importantly, the one important thing to keep in mind is that it's voluntary, meaning just because you request it doesn't mean you're going to get it. Both sides must agree to participate. While the board or court could recommend it, again, generally both sides need to agree. At the Court of Federal Claims, the judge can do it, meaning the judge can oversee the ADR, or you can have a neutral party through mediation, or you can have a mini trial. There's lots of different ways and forms that ADR could take place at the boards. It's similar at the Court of Federal Claims. You could have mediation or a mini trial. You could ask for an advisory opinion, or you could have binding arbitration. But generally, ADR is a method that is used, frankly, really pretty frequently. But it really depends on what the parties are willing to agree to. And it's used frequently simply because it's a way to hopefully save costs and arrive at a resolution, hopefully in your favor, faster than it otherwise would be if you went through the full decision-making process. And that is the last slide. So we'll turn to some of the questions. We only have 5 minutes. And we have a number of questions. If we don't get to your question, we will follow up with an email. So just because we don't get to it, it doesn't mean it's not going to get answered. It will. Yes, we will send you a copy of the slides. Does the claim have to start as an REA? If denied, then a claim? No. And this goes back to what I was saying earlier. They're really two distinct animals. And an REA is really submitted at a time when there is no dispute. You're really negotiating. A claim, on the other hand, is typically we would particularly recommend to submit if there's already a dispute as to, for example, whether the government owes you additional money. But no, you don't have to wait for an REA to get denied and then file a claim. But you can file an REA, have it be denied, and then go to a claim. During a claim, what if the CO was changed during the contract period, which caused in part the claim itself? In that scenario, you're going to go to the current contracting officer, but that's a good question. Let me see. How are we getting credit for this course? I don't know, frankly. I don't. If you want to send me if you want to send me a separate email, I'd be happy to look into that. I'm just going to this. Larissa, are there any that you feel that you want to answer? Jump in. The acronym REA, it's a request for equitable adjustment. Someone asked when you should submit REAs for anticipatory costs. For example, anticipated material escalation costs resulting from a government delay. You don't want to submit an REA until you have cost to recover. So you don't want to submit an REA in advance of incurring those costs, but what you probably want to do is just give the CO a heads up that at some point, either during contract performance or at the end, an REA is coming their way. Just giving them a heads up.
There was one that I thought was interesting. It says, I've observed a decision-making process facing the choice to submit a claim versus REA based on the fact that claims require the government to respond in 30 days. So just as a way to basically get the government to respond to you instead of doing an REA, I mean, I would caution you and say, look to see if there's a dispute. If you think it's going to be amicable, do the REA. Hopefully you already have that good relationship with the CO. So they'll respond in a timely manner. They're getting a lot of REAs right now, so it may take longer than 30 days, but they are going to do it in order of what they, the order of operations of when they get them. And if they have the full package and it's easier for them to review, they'll respond more quickly, less likely to bounce it back.
Someone asked, is it typically the CO that decides to grant or deny a claim REA, or will the final decision typically come from farther up the ladder? The decision is going to come from the CO, but obviously the CO's knowledge in terms of entitlement is limited, and oftentimes they will bring in an expert to see, for example, if this delay impacted the critical path of performance, or to review your damages calculation. So yeah, I mean, there's a lot of stuff going on behind the scenes, but at the end of the day, the decision is going to come from the CO. And so we've run out of time. There are a few here that we didn't have an opportunity to answer, but like I said, we have your contact information. So for those individuals whose questions weren't answered, we will get back to you at sometime this week. So again, here's our contact information. You're welcome to reach out to us directly if you have additional questions. But thank you, everyone, for attending the webinar, and I do hope that it was helpful.
Yes, thank you.
And thank you.